My lord, my lord,
Yes.
Well, application for bail.
My lord, I pray to mention
Bail.
Bail, well, court number 20 is not sitting. Well,
No. Bail. We don't have jurisdiction.
court number 20 is not sitting. Well,
Not sitting. We have not got the assignment. You wait.
Well,
Huh?
well,
Wait, because we have not got the assignment of the
well,
jurisdiction.
well.
Please give notice to the state. If it is assigned,
Right.
then all the slips will be taken in. We'll take up at
Upon
2
notice,
p.m.
Well, upon
the
notice.
list published.
Well,
Yes.
my lord, there is a
Notice.
matter that has been specifically assigned before your lordship. The matter had been assigned on 5th November, my lord. It has yet to be taken up on the list, my lord. This is
You have not reached.
my lord, this is a contempt application in respect of the Arnish Kumar Jha.
Yes, Mr. Chairman.
my lord, your lordship possibly remember in a contempt matter, we are the respondent, HSCL, Hindustan Steelworks Construction Limited. We are the government concern of the central government. Now the KOPT is, my lord, your lordship has the jurisdiction under 19(1)(a), and your lordship has entertained it.
19(1)(a).
Yes, 19(1)(a) of the Contempt of Court Act, and your lordship has already directed Mr. Piyush Chaturvedi to have inspection, and it was already fixed on 11th. But my lord, that for your lordships, all these problems or whatever maybe, my lord, for any other reason, my lord, we do not know. My lord, the matter could not be taken up. My lord, that your lordship possibly remember that we have also given one application. That means that they are going to take possession of our property. And my lord, that on 11th the matter could not be taken up, and we have somehow restrained them at least that to take up the matter on 12th. Thereafter, my lord, that we were expecting that your lordship will take up the matter today, and my lord, that we were up to 6:30, 6:25. We have been informed that your matter is in the list. And my lord, just my lord, that on Tuesday, my lord, the matter was. My lord, now we have been stated that the no matter will not be, because the lordship's pleasure is not to take up this matter. My lord, if that be the position, my lord, this is the 11th, my lord, and they will take possession on Tuesday. My lord, yes, my lord. Tuesday is the, my lord, possession, my lord, that let the matter be taken up on Monday, my lord. I am with Sardar Amjad Ali, my lord, and my lord, that if the matter will not be taken up, my lord, will be dispossessed, my lord, with the government company, my lord.
Next Friday.
My lord, if the matter, my lord, then Monday, Tuesday, I must have to be saved.
Released from my list.
No, my lord, not that. My lord, you are not. Yes, let it be Friday. No problem.
From my list.
No, my lord, no problem, my lord. No, my lord. Let it be on Friday.
By
No, yes, my lord, on Friday.
Released.
No,
we are informing you. We are
my lord,
releasing.
No, my lord.
We are releasing your matter. Yes.
My lord, because my lord, the problem we are here at least to solve.
What is your problem?
No, it's not my problem. It's the problem of the institution.
Yes, our institution's problem. We are releasing.
No, my lord, that the release is a solution. Let me say, my lord, release is a solution. My lord, your lord, Darao.
Yes.
My lord, that your my lord, your lordship should not release it because that
Mr. Counsel.
My lord, your lordship knows, my lord. Your lordship knows, my lord. Kindly, my lord, your lordship fix any day. But my lord, that it's not, my lord.
Then don't dictate us.
Yeah, I'm not dictating.
We are not accustomed
to
rising of
no, my lord. My lord, at the age of 72, my lord, after covering 45 years of age,
I'm not concerned about your
my lord. Yes, my lord.
We are not concerned.
But my lord,
about
my lord, yes, my lord. At your lordship's pleasure, my lord, my lord, maybe, my lord. But my lord, lawyer's duty at least to insist. That does not basically mean, my lord, that he will be in trouble and your lordship will be in trouble. My lord, yes, my lord. I am grateful to your lordship.
Not to insist.
My lord.
Is to plead. Not to insist. To plead. And when you cross that red line,
yes, it is true.
To put you again back.
My lord, it is true, my lord.
So now that you are back,
my lord,
we will take it up on Friday.
My lord, I'm grateful, my lord.
Well, a writ petition challenging attachment order under PML, I had mentioned the matter yesterday. Now, Lordship, last evening, my client has received a notice under Rule 5 saying that I have to hand over physical possession of the property, which is the subject matter of the writ petition, by next Sunday, so that it can be
next Thursday it will come up. Take out application challenging the whatever.
May I have your lordship's leave to Lord, may I have your lordship?
Lord, may I be permitted to mention a bail in connection with the Lord, may I be permitted to mention a bail in connection with the plea?
But may be permitted to mention
I'm
a
grateful,
matter
Your
bail
Lordship.
in connection with appeal. Another matter bail in.
The
Another
bail in connection with the appeal, was it rejected earlier?
No, my lord.
No.
It's a fresh application.
first time.
Just call the list.
Lord, may I have your lordship slip, Lord, to mention Lord item number 38, Lord. Lord, item number 38. Lord, I'm just only praying for not today. Lord, I'm not,
When it is called, we will look into it.
as your lordship please.
Yes.
Original side matter. Application item number 1.
I am for the
Lord,
respondent.
I am for the appeal in my lord contempt. My lord, this is a short list of dates. It will help, my lord, because there are, my lord, 4 volumes. My lord, very short point involved in this matter. This is the, my lord, service.
So, what is the order by which you are aggrieved?
My lord, container have been, my lord, sent to jail. Warrant of arrest was issued, my lord, in an interlocutory application.
Now they are not in jail.
No, my lord, we have been, my lord, appeared and, my lord, accordingly released. But, my lord, my lord, contempt proceedings is bad in law. It could not be
Bad in
proceeded.
law will be seen by the
Yes,
judge.
my lord, the contempt court,
18 September 2000.
contempt court directed me to pay payment on.
It is contended that the direction for making payment is not within the
My lord,
Oh,
my lord, kindly allow me. My lord, kindly allow me. My lord, kindly allow me. My lord, my lord,
take down.
my lord, kindly allow me 1 minute time, my lord, because, my lord, against an interlocutory order, my lord, this contempt application is filed. Subsequently, suit was decreed and appeal was carried out. And in the appeal court, there was an order of status quo. We have taken into, my lord, point before the learned, my lord, contempt court that, my lord, maintainability, my lord, merger, because after filing the final judgment, the interlocutory, my lord, order would, my lord, merge with the, my lord, final judgment. And we have filed one opposition stating, my lord, specifically that the contempt proceedings is bad in law. That has not been, my lord, taken up for hearing. Only, my lord, we have been directed to payment on the basis of the statement, my lord, advanced by the, my lord, the respondent. My lord, that is, my lord, that is why we are aggrieved. The contempt court, my lord, did not hear out their contempt application with regard to maintainability of the contempt proceedings. My lord, directed to send prison. Subsequently, on the basis of the statement given, my lord, by the, my lord, the respondent, we have been directed to pay. Is a huge amount. My lord, my lord, appeal, my lord, if we pay, appeal will be infructuous because my lord, judgment, my lord, I am covered by the Supreme Court judgment. My lord, 4 judgments are there. When, my lord, final judgment has been passed, my lord, interlocutory order would merge with the final judgment.
Dispute about it. If an interlocutory order,
My lord, kindly clarified it, my lord, and my lord, the contempt proceedings is bad in law. It is required to be stayed unless till disposal of the appeal, because, my lord, this is not any, my lord, executing court on the basis of the
executing court.
my lord, no, they have not filed, my lord, they have filed one execution. I am not. I'm sorry, my lord. I'm my lord, execution. No, my lord, they have filed one.
Contempt court, civil contempt is not an executing court.
Certainly, my lord, executing court.
If it is an executing court, the merger doctrine does not apply.
My lord,
If there is an interlocutory order and there is a violation, the contempt jurisdiction is fully preserved. Even, sir, let
My
us
lord.
remind you Even when an interlocutory order is vacated, there is a residual jurisdiction of the judge to entertain an application under Order 39 Rule 2A. So a contempt jurisdiction wider than Order 39 Rule.
Order 39, my lord, I am covered by the Supreme Court judgment. Order 39 Rule 2A, my lord, Order 39 Rule 2A would not be arise.
Passing the order, please go to the Supreme Court.
No, my lord, we are not
Right.
Supreme Court, my lord. We
have
know,
no
my lord.
reason to interfere.
We know, but my lord, contempt is required to be decided. Maintainability point has required to be decided by the learned.
Decided by the judge.
My lord, kindly clarify that point.
Yes.
Yes, my lord. My
I will-
opposition is required to be,
I
my
will
lord,
take-
considered.
My lord, I will not take much time. My lord, the order, my lord, which is my lord subject matter of contempt, my lord, that is an undertaking given in court by my learned friends, my lord, client. My lord, that is number one. Later, my lord, there has been my lord, satisfaction of the order. They partly complied with it, and thereafter they have taken out an application for modification, which was dismissed.
This undertaking was given
My lord,
by the alleged contemner
my lord.
after or before the order of status quo was passed by the appellate court.
My lord, before the order, but in any event, my lord, the decree which is
If there
passed.
is an order of status quo with regard to the decree passed,
My lord, there is no status quo order. My lord, there is, in fact, my lord, the order of the Honorable Appeal Court is very clear that there is no stay so far as the eviction decree is concerned. My
Right.
lord, the decree which is passed is for eviction. For mean profit, my lord, it's still pending. The proceeding is still pending.
right.
My lord, my
Now,
lord,
what is the amount due and payable in the chart?
They
Yes,
claim, my
We
lord.
are not asking you anything.
my lord, the amount is, my lord, exact, my lord, 84 lakh, my lord, odd amount.
Against what?
My lord, in respect of the 6th May order, which, my lord, my learned friend is
How that amount becomes due and payable?
Yes,
As
my lord.
what?
My lord,
Rent?
rent, my lord, and my lord, area occupational charges plus GST amount. My lord, this is the undertaking given to them, and my lord, in the affidavit in opposition that my learned friend has
Was it
filed,
a part of the decree?
my lord, no. My lord, it's not part of the decree, but my lord, this is, my lord, the undertaking which they have given in court.
So this is not a part of the decree.
My lord, decree is eviction. Only eviction.
Decree was of eviction.
My lord, which
And-
is, my lord, appealed against.
And the undertaking is in respect of outstanding
My lord, occupational charges and my lord, area occupational charges.
occupational charges and area of
My lord, and my lord,
now,
thereafter,
now this would be merging with the mean profits.
my lord, the thing is, the mean profit proceeding is still ongoing.
That is why we are saying would
My
be
lord.
merging with the mean profit, right?
My lord, my lord, the
So as of now, what we say is
my lord,
the order so far as partly which has been yes, he has given an undertaking,
my lord,
and now he says that the maintainability in view of the orders passed by the appeal court,
my lord, with the
that
greatest,
issue should also be decided by the honorable single judge.
my lord, with the greatest of respect, my lord, that issue, my lord, is, my lord, barred by res judicata, because, my lord, when the undertaking was given, thereafter there has been part compliance, and thereafter they took out a modification application which was dismissed. And my lord, in the modification of, if I may show, my lord, that order, my lord, kindly sees, my lord, the 29th August order at page 221. My lord,
Second volume.
my lord, it's in the second volume. My lord, if I may place, my lord, my lord, if I may place, my lord, this is an application for modification of an order dated 6 May 2022. The suit is filed for eviction and mean profit. The defendant is enjoying the suit premises comprising of an office block measuring 2,400 square feet situated at the first floor of 19 RN Mukherjee Road, Kolkata 7,01,000. The application has been filed by the defendant tenant seeking modification of an earlier order dated 6 May 2022, primarily on the ground that the defendant is suffering from acute financial crisis. It is also contended on behalf of the defendant tenant that there is a mistake in so far as the exact area being occupied by the defendant is concerned. A suit to this effect has also been filed by the Learned City Civil Court at Kolkata. Now, my lord, kindly sees the order, my lord, 6 May, my lord, that order, my lord, if I may place, my lord, this court had directed the defendant tenant to pay a sum of rupees 1,25,000 along with GST on account of the occupational charges in respect of the suit premises. My lord, thereafter the order is set aside. My lord, the order is set out.
Set up.
My lord, my lord, I stand corrected.
Right.
My lord, then my lord, kindly sees, my lord, at the bottom, last two para. I have considered the submissions made on behalf of the applicant. At the outset, order dated 6 May 22 has also been complied with on earlier occasions. Admittedly, the defendant tenant continues to occupy and use the suit premises for commercial purposes. In my view, both the grounds contended on behalf of the applicant are without basis, ill-motivated and misconceived. In view of the aforesaid plea of financial crisis as well as pendency of suit filed in the City Civil Court, Calcutta, are inequitable and not tenable either on facts or in law. And my lord, that GA was dismissed.
Right.
Now, my lord, what has happened? My lord, I filed the contempt proceeding in, my lord, June 2023. My lord, series of orders have been passed in the contempt. My lord, rule was issued on the 18th of July 2023. Thereafter, my lord, the rule could not be served on the 3 contemners. Out of that, my lord, the appellant is, my lord, number 1. My lord,
Then the judge issued warrant.
warrant. And my lord, we have also, my lord, made, my lord, substituted service. Warrant was issued, my lord, first time on 24th of January 2024. Thereafter, they were produced in court, my lord, the contender number 1 and 2. My lord, thereafter, again, they did not, my lord, they were not represented. So, my lord, second time the contempt, my lord, the arrest warrant was issued on 12th of August 2024. My lord, if my lord kindly sees this order, my lord, 12th of August, my lord, this is also, my lord, very important because, my lord, so many things have happened in, my lord, since, my lord, filing of the contempt proceeding, my lord, and those orders are not under challenge. My lord, kindly sees 12th August order, it's not under challenge. My lord, it's at, my lord, page 518.
18 September order is under challenge.
My lord.
Huh?
My lord, 18 September order is under challenge. But my lord, all the previous orders which
What
are
happened
passed.
to the 18 September order?
My lord, 18 September order, what has happened? My lord, 12th September, my lord, 12th August, my lord, arrest warrant was issued. 18 September, they, my lord, took out an application for recall. But on that day, my lord, they produced, my lord, contemner number 1 and 2. So, my lord, the contemners were released. And my lord, the contemners were directed to consider our claim for, my lord, occupational
The
charges.
saying is what happens to the 18 September appeal?
My lord, that is before, my lord.
No, 18 September is not under appeal.
My lord, that is the my lord, order challenged against.
The order challenged is
18 September.
it is the
8th September.
18 September.
My lord, kindly sees, my lord, 12th August order once, my lord. Everything, my lord, is succinctly, my lord, put, my lord, recorded in that order and which is not under challenge. My lord, 518, my lord, if I may please.
This order is not challenged, right?
Yes,
The
my lord.
earlier vacating application has not been challenged.
Not challenged, my lord.
That is 200,
My lord, 508. That order is 221, my lord.
221.
In memo of appeal, there is my lord order. Certified copy of that.
Five 36 is one order, right?
My lord, 518, my lord.
No, 22. The order that you just showed us. Second volume that order to put. Volume 1.
121.
Second volume. ওটা তো প্রেস করলে
221.
Let us see.
ঠিক
এখানে একটা এই আছে marker।
Login ছিল।
29th August, that has not been challenged.
Not challenged, my lord. In fact, my lord, they made certain payments after 29th August also. And my lord, I have given, my lord, adjustment of all the amounts that I have received.
That is for the single justice.
My lord, my lord. My lord, the next order which I will rely upon, my lord, is, my lord, at page 518
Yes,
in the fourth volume, my lord.
518. Yes.
My lord. My lord, my lord, if I may please, my lord. This is an application alleging violation of contempt of an order dated 6 May 2022. By the said order, this court had inter alia directed as follows. So, my lord, the order is set out. My lord, at the next page, my lord, if my lord kindly takes, this application was filed as far back as on 22nd June 2023, and repeated orders have been passed from time to time. Initially, the alleged contemners were avoiding service. Thereafter, substituted service had been effected in terms of the order dated 30th September 2023. Subsequently, despite substituted service, the alleged contemners remained unrepresented. Thereafter, warrants of arrest were issued on 24th January 2024. Pursuant to the above, the alleged contemner number 2.
The process of court, in the meantime, takes out an application for modification, dismissed, not challenged, becomes final.
My lord, may I continue, my lord?
এখন তো সে ফেস করতে হচ্ছে না।
Pursuant to the above, the alleged contemner number 1 had also appeared in court on 6th of February. Thereafter, despite an undertaking dated 14th December 2023, the contemners have refused to make payment and simply procrastinate and delay the hearing of this petition. An adjournment is sought for on behalf of the alleged contemner numbers 1 and 2. It is obvious that the alleged contemners are not interested in complying with the orders of court and continue to adopt evasive dilatory tactics to frustrate this application. In view of the above, let there be warrants of arrest issued against all the 3 alleged contemners. The officer in charge of the concerned police station and the jurisdictional superintendent of police are directed to ensure compliance with the order of this court. So, my lord, this is the second time when the arrest warrant was issued. And, my lord, they were evading, my lord, the arrest warrant. My lord, police was also could not find them.
So today the argument is because the suit has been decreed, interim order merges with the decree, and therefore the contempt proceeding is not maintained.
My lord.
What is your response to that?
My lord, my response is, my lord, these points have been taken, my lord, repeatedly everywhere. My lord, these are, my lord.
Where have they taken?
My lord, what has happened, my lord, in the meantime, the
Taken out
suit,
this point in any application before the learned single judge?
my lord, the suit has been decreed so far as the eviction is concerned. And there are,
Have they taken out this issue before the learned single judge in any application post the application for vacating on 29th of August 2022?
my lord, before the appeal court, number 1, and secondly, before, my lord, the writ court.
Have they taken out this point before the learned single judge in the contempt proceeding?
My lord, in the affidavit, they have filed an affidavit in opposition.
They have said this.
My lord, in the affidavit in opposition,
Yes.
my lord, they have not challenged, my lord, the outstanding dues which I have given in a
Madam, we
charge.
are asking again another question.
My lord.
Have they taken up this issue before the single judge that the decree have interim relief order merging in the decree, the order does not survive and therefore contempt the entire proceedings should be dropped, or that is there in the affidavit, right? It is there. Your argument is this has got nothing to do with the decree.
My lord.
It's an interim arrangement and the honorable judge subsists jurisdiction notwithstanding the decree.
My lord, if I may say so, my lord, if my lord kindly takes the order of 6th May. My lord, the 6th May order says that till disposal of GA2 of 22, where the order was passed. My lord, GA2 of 22 is still pending. My lord, kindly sees, my lord, page 77. My lord, which is, my lord, the 6th May order. My lord, the first paragraph, if I may show, my lord, 6th May order. Without prejudice to the rights and contentions of the parties, the defendant undertakes to pay a sum of rupees 1,25,000 along with GST on account of occupational charges of the suit premises to the petitioner till the pendency of this application. And this application is, my lord, GA2 of 22. This application is still pending.
What is the relief in that?
My lord, the relief is, my lord, what has
When
happened.
that suit is decreed, the application will survive.
My lord, I have, my lord, in the suit prayed for eviction and mean profit. My lord, eviction decree is passed. So far as mean profit
decree is abated.
awaited.
Correct.
And my lord, the thing is, my lord, this application we have
So
taken
you
out.
given the answer. The suit has not been fully decreed.
My lord,
And therefore, the undertaking in the GA
survive.
pending the suit for mean profit is subsisting.
My lord.
Right. Yes, what do you say?
My lord, in their GA2 of 2022, my lord, interlocutory application, they have claimed 37 lakhs as one occupational charge along with GST. That is their initial claim.
What is your undertaking has to be enforced.
My lord, they are
What
subsequently
is your undertaking, sir?
undertaking, my lord. Yes, my lord. We have
And
paid.
that adjudication,
Yes.
whether the undertaking should be enforced or not, is squarely within the jurisdiction of the judge who has issued the rule.
My lord is rightly pointed out in opposition filed in contempt in paragraph number 12 and 13. My lord, we have taken out the point of maintainability and merger.
Right.
Since the judgment has been passed and decree has been passed.
Correct.
So, my lord, the learned single judge is ouster of jurisdiction.
Right.
That opposition has not taken into before hearing. My lord, the learned judge directed us to pay 84 lakhs, though their claim is 37 lakhs in GA2. Their claim is, my lord, it appears, my lord, page 119 to 130, they are claiming 37 lakhs as occupational charge. But when they have given the, my lord, on pressure, my lord, they have given.
Defendant undertakes to pay a sum of rupees 1,25,000
Yes.
on account of occupational charges till the, along with GST, till the pendency of this application.
My lord, before execution, we have been thrown out.
Hmm.
My lord, by the help of the local police and hooligans, we have been thrown out. We taken out one writ petition alleging that police without any execution proceedings.
Undertaking, sir, your
My lord.
undertaking is of occupational charges along with GST since April 2022 till April 2000, from April 2020 till
2 years.
April
2 years.
2022.
Yes.
Has that been liquidated?
Some partly complied with.
Please comply with the other part.
My lord, with regard to, my lord,
Please comply with the
my
other
lord, with regard
Take
to,
down.
my lord, with regard to maintainability is required to be
Yes, now
decided.
we'll answer the maintainability
Ma-
here and now.
And my lord, your lordship is rightly pointed out. My lord, since the final judgment decree has been passed and that is carried out, appeal is pending. So, my lord, mean profit that has not been decided. They have not taken out any step for mean profit. My lord, in spite of they are taking steps in, my lord, contempt proceedings, which was an interlocutory in nature. So, my lord, respect to submission.
You have repeated. You have already said that.
My lord.
We have elicited the response. Now let us give the order.
My lord, grateful.
Appellant contemners have appealed against judgment and order dated so and so. Judgment and order dated so and so.
What list of dates I have given the dates, man?
Now we've got it.
Yes, man. We have
Judgment and
given.
order dated 18 September 2024, whereby the appellants were produced. One of the appellants, both the appellants are before us.
Both the appellants, one and one is the appellant, but both contemners are 1 and 2. They were.
Hey, sir, who is the appellant? Appellant
One.
Contender number
Your
1.
appellant, contemner number 1, has appealed against so and so. whereby the said contemner and contemner number 2 were produced under arrest and the contemners were given liberty to take necessary instructions with regard to the alleged dues payable by them. Thrust of the challenge to the order is that the suit that the suit for eviction had since been decreed and an appeal is pending. Once the decree was passed, the interim order whose alleged violation had given rise to the contempt proceeding no longer survives. Hence, the contempt proceedings are wholly without jurisdiction, and the direction to take instructions for payment of alleged dues was beyond the scope, was illegal and was illegal. We'll stop. Brief conspectus of facts giving rise to the present proceeding is as follows. A suit for eviction was instituted against the contemners, right?
Against the company, contemner is the one of the partner of the company.
Against the partnership firm, my lord.
Against the contemners company
My lord, it's a
during
partnership
the
firm.
in the suit. Now, in GA 2/2022, alleged contemner, appellant, the contemners made an undertaking, gave an undertaking to pay occupational charges since April 2020 till April 2022 22 in 12 equal monthly installments, full stop. The first of which was to commence from May 2022. The undertaking was recorded in order dated 6th May 2022 as follows. Set out page 222, volume 2. Volume 2. Good stuff. The contemners failed and or neglected to, the contemners did not make payments in terms of the undertaking. On the contrary, they took out an application for vacating, for setting aside the order dated
6th of May, my lord.
The aforesaid order. Took out an application for modification of the aforesaid order on the ground of financial crisis. The application was dismissed on 29th August 2022. Thereafter, the contemners partly complied with the undertaking and made certain payments. In the meantime, eviction decree came to be passed, which has been challenged in appeal. As the contempt proceeding was initiated before the eviction decree, right?
Yes, my lord.
Partly paid. However, as the entire dues had not been paid as per the undertaking, the respondent plaintiff took out an application, took out a contempt proceeding. During the pendency of the contempt proceeding, eviction decree came to be passed and has been carried in appeal. Stop. Contempt proceedings continue. Before the in the contempt proceedings, the contemners as the contemners failed to appear before the in the contempt proceeding, in spite of service upon the applicants, upon the alleged contemners, they did not enter appearance in the contempt proceeding, and warrant of arrest was issued on 24th January 2024. One of the contemner number 2 was produced under arrest. Now, thereafter, the contemners appeared. Now, one of the contemners was produced under arrest. Appellant contemner under number 1 also appeared before the court. And gave a further undertaking on 14th December 2023. But the contemners, in spite of the undertaking, the contemners again adopted evasive and dilatory tactics to delay the contempt proceeding, and warrant of arrest came to be issued. And by order dated 12th of August 2024, warrant of arrest came to be issued. The said or this order was not challenged by the appellant contemner. They were the contemners were arrested and produced before the honorable single judge on 18th September 2020, produced before this honorable single judge, and by impugned order dated 18th September 2024, they were directed to take instruction to pay the alleged dues. Appellant contend the direction for payment of alleged dues is illegal, as the interim order dated 6th May 2022 has merged in the final decree. We are unable to accept this proposition. The suit had been filed for eviction and mean profits. It had been partly decreed. An eviction decree was passed, but the suit is pending for mean profits, pending with regard to mean profits. With regard to mean profits and the interim order, mean profits. During the interim order survives till the disposal, till the final disposal of the mean profits. Interim order passed in GA therefore survives till the said interlocutory application is disposed of. কি বললাম যেন was therefore survives therefore survives and the therefore survives. Appellant contempt proceeding has been instituted to enforce an undertaking given by the contemners in GS1 suit. Enforcement of an undertaking given by a court undertaking given by a litigant. Enforcement of an undertaking given by a litigant would continue notwithstanding disposal of the proceeding until and unless the said undertaking is either withdrawn or set or is either withdrawn or held or is either withdrawn or set aside by the court. Full stop. Accordingly, we are of the opinion there is no jurisdictional error in continuing the contempt proceedings against the appellant number one, appellant contemner against the appellant and other contemners. Full stop. Appeal is dismissed.
Grateful.
My lord, with regard, my lord, appeal is dismissed, but my lord, point is, my lord, we had paid some amount.
Next.
My lord, some time is required.
Next.
My lord, only one thing. My lord, the defendant tenant was a partnership firm, my lord. My lord, it has gone down as company, my lord.
The firm.
Is partnership firm, my lord. Sorry, my lord. Sorry, my lord. Firm.
Appellant's firm.
Appellant's firm. Appellant's firm.
Right.
Wrongly, my lord, I have said. My lord.
Deeply obliged.
The bail applications, any mentioning, will be taken up at
Grateful, your lordship.
My lord, one bail application that is not there in the list. The difficulty is, my lord, the mother of the one of the petitioners expired on 18th. We have filed the application on 19th. It was supposed to be listed today, my lord. Somehow it has not been listed. May I mention the matter?
it will be listed in the outside list. Give a notice.
My lord.
Whatever, we won't be able to pass your order, whether the mother has died or not, request to be verified.
We have got the cremation certificate.
Correct. So whether that's a genuine certificate or not, who is going to say? You are not aware. You were not present at the time of
sir,
cremation. Neither were you. We need Mr. Nondi.
This is my NCB, my lord. NCB.
To the another. They will take instruction from Delhi with regard to cremation. So wait for the next cremation, they will come. We'll keep it on the list, give notice to NCB.
My lord.
No, it's okay.
Right. So no, one I'm for the petitioner. My lordship, is that matter where illegal arrest was there. Your lordship has asked me
The
to give
defect of
list of
complainant,
dates that are prepared, that have circulated. Now, my lord, I'm also submitting. Now, last day, your lordship has asked me, that is not recorded, to go through the judgments pertaining to the compensation with respect to illegal arrest. My lord, done research. But the only thing is that, my lord, it is appearing alongside, and if your lordship kindly takes it on Monday, I will give a compilation.
These are.
Let me go through that also.
No, no.
Give me the list of dates and other documents.
লিস্ট দিয়েছি দাদা লাজিম দিয়েছি এ দেখো
We'll
আচ্ছা আমি
keep
আবার
it
দিয়ে
next
দিচ্ছি
Friday.
মাইল
Next Friday. You are available next Friday? Not available. You are going for holiday. What?
Another 6 days.
Another 6 days.
Sister,
Sister marriage.
back to
How many marriages you are going to have? Your own sister? No, you don't have any own sister. All cousins. As of now, let us keep it on.
after 29th, I'm there.
Yes. So we keep it on 30th, right? And then we'll fix another.
Sunday, Saturday.
On
30th is Saturday.
Saturday.
on 29th. We'll keep it on 29th, right?
Second, Malak. Second.
Second we can. Second, how can we keep? These are matters which are parted and contempt matter. These are contempt matter. This bench should not be. So let us as of now keep it on 29th. Okay. If you are in difficulty, we will post again maybe on 13th or 14th. Okay.
Deeply
On
blessed.
pair of parties fixed on 29th.
আমি আজকে দিয়ে দিচ্ছি আচ্ছা দেখ
Yes, how many sisters I don't know.
Sister, cousin, local, elder brother.
Local.
You don't know. It's too much of social responsibility.
Social activity.
Social, personal, many responsibility.
I don't have any.
Yes. Next matter.
This is my contempt application, my lord. ওরা কোথায়? The number is all right, but cost title number is all right, but the cost name of the applicant is wrong.
All right. Then we'll keep it.
No,
next.
next one is all the same. This is a contempt application. My learned friend is
The cost title like him, my lord, because
Oh, you are appearing.
no, my lord, he wrongly printed.
name number is same,
So let it be not today. Next Friday we pass.
Not that is against our corporation.
and the next one is rightly printed.
So both matters will pass orders.
Next page আবার ওখানে থাকবে।
Wrong. Actual ones I am appearing, my lord, for the contempt.
দুটো ঠিক আছে।
So if you are entering appearance, then we can pass the order.
Your lord may take up the matter.
All right, then we take up.
You should may take up.
If both parties are there, then
Yes,
we
yes.
can take up. Otherwise, there's a mistake in the cost type. So same order we can pass.
Yes, common order. vacancy.
Same order we will pass.
Same order pass code.
Yes, yes, yes.
Similar, these are
After hearing, after
Hearing.
on last occasion, you will,
No, if your lordship is proposing to pass any order, but I'm not aware what order.
no, after hearing.
earlier contempt.
This is a contempt application. Initially, they have filed a report. Your lordship has not
The two
satisfied.
has not been taken up as yet.
Oh,
He is explaining that in two, the name has gone down incorrectly.
Hmm.
And in three, Malad, the,
Like
there has been,
কোনটা কারেন্ট না?
the printing has gone wrong.
All right. Now you file your affidavits then.
But I'll find.
Affidavits we
But
file.
this is the second affidavit. Initially, they have filed a report in the form of affidavit.
That is in the appeal.
No, no.
I'm filing. Not filing. Filing.
হ্যাঁ, copy দিয়েছো।
This is where
Item number two, Malad.
item number 2. 3 you have already filed.
Three also I'll file.
All right. Then Mr. Shara, you look into this. We keep it 2 weeks hence.
2 weeks.
I have gone through it because long back they have served it.
So if they do not wish to file any exception to it, your lordship may take it up. Malad.
All right. So let us take it up. Today we'll take up or
I have no difficulty.
next Friday we take up.
I have no
Next
difficulty.
Friday.
Then Friday will.
Next Friday.
Next Friday কখনো থাকে?
29.
মানে Friday another matter is fixed. Friday week.
2 weeks.
No, Friday. Because one matter today I could not go there.
Then this will come up on 13th of December.
But in item three also.
But in the meantime, if necessary, I shall file an exception and hand over the copy.
All right. Report is filed on behalf of the alleged contemners. Exceptions, if any, be filed by the adjourned date. Matter will appear on 13th. Yes.
এগুলো নেই। পরে থাকবে।
Not today. Not today. 4 is not.
This matter had appeared
for the appellant.
the other bench, and it has been discussed already. But I do not find any order recorded that is a matter.
All right, released.
Well, the order was dictated in pronounced in open court, but the order is not made available. It's not available on the website.
Which
the-
order was?
The order which has been passed. Yes,
by
day before yesterday, the appeal was dismissed
By
by the regular bench. Yes.
So this is we say that no order need be passed. The file is before us.
Yes, that is what I'm told. I do not understand.
I was before the court.
The file is also here, I'm told.
I don't know what whether the file has the independent comment.
Right. File আছে?
File is not there. The file of the matter had already been
That
heard
is
and-
what we are saying. But a list করলে কি করে file sir?
The last order says matter to appear on third
Yes.
by your lordship. 13th.
To pass any order.
Grateful.
Yes.
Lordship, I'm for the applicant petitioner, Lordship.
The six I'm for the contempt number one.
Here has made a mistake, my lord. There was a direction to file an affidavit. My lord, it was affirmed on 7th of October within time, but my lord, he forgot to, my lord, serve on my learned friend, my lord.
All right, file your affidavit.
My lord. And I'm
Lordship,
handing up a copy to my learned friend.
I'm filing the reply against the opposition of filed by the contemptor number 2, Lordship. Okay. Thank you.
Sorry, I don't
Yes, no, no, no.
Affidavit in opposition by alleged contemptor number 2
Lordships.
is placed and the state.
I'm yes, I'm contender number 1.
You have not filed.
I filed it. I've served today, my lord.
Affidavits in opposition, but alleged contemptor number 2 was supposed to file there.
2 has been filed. I'm filing the reply today.
I'm also. What is it?
Yes, Lordship, I have
Mr.
filed.
Chatterjee, you are for
Contender number 1, my lord.
So you are also filing affidavit.
Lordships.
There
was a direction
by alleged contemptors are placed on record. Affidavit in reply is also placed on record. Okay. We'll give the
Lordship, I have I went to serve him, but
let the matter appear on 14th.
yes, Lordship, 14. One more indulgence, Lordship. I have not received the copy of the medical report of the victim, Lordship. They have produced before the court, but I have not received the copy that day.
I'll going on.
Trial is in progress, my lord.
The victim girl has been examined. He is presenting the
Yes,
accused.
Lordship,
So
but I have
copies-
not received the copy yet. No, not me. Lordship, that one has been produced before the court, but the copy that day I have not received.
Medical report of what?
The medical report of the victim, Lordship. That has been
That has got
produced.
nothing to do with your arrest.
Grateful, Lordship.
If necessary, we will direct the state, your state, will direct the state to produce relevant records. Let us hear you and thereafter.
I'm deep.
Next. 13th, 12th,
14th.
Deep blue.
13th of December. 13th of December.
13th minutes.
13th.
Deep blue. 13th. Okay.
Lordship, in this I appear on behalf of the petitioner, Lordship. Lordship, I'm praying for not today since the conducting advocate, Lordship, he had a bereavement in his family yesterday night only.
After vacation.
After this. All right.
Next. Yes, Mr.
Your Lordship.
Senior Government Advocate.
But now additional government leader, though, my lord. But
Additional
your lordship kindly call me as Mr. Banerjee. I'll be so
additional
happy.
government leader.
Your Lordship, on behalf of the petitioner, I am praying for Passover. Short
Let
Passover.
review.
Number 42, Your Lordship, kindly.
Review.
Your Lordship, kindly make it Passover, Your Lordship.
Once again.
Okay. Okay. What time?
12th.
Yes, grateful.
12th December
Your
Your
lordship
lordship.
kindly make it pass.
December কি বার পড়েছে?
Applicant seeks adjournment 12th December.
Number.
Yes. Call the anticipatory.
My lords, I beg to appear for the petitioner item number 9. I'll give a brief gist about the matter, my lords. My lords, I am an alcohol manufacturer. On 21st May 21, I executed a contract for promotion with the complainant, my lords. The terms of the agreement were such. Number one, my lords, he had to pay 60 lakh rupees non-refundable at the time of signing of the contract. He pays the amount during the course of the year, my lords. Secondly, my lords, the term of the contract was for a period of 5 years. My lords, agreement is at Annexure 3, page number 23, my lords.
Did you meet the investigating officer?
My lords, number one, my lords, I was diagnosed with dengue, my lords, on 9th November itself. Secondly, my lords,
And 4 weeks. In the meantime, the petitioner shall meet the investigating officer once in a week until further orders.
my lords, I want to point one important fact before my lords. My lords, I was granted interim protection on 7th November. My lords, the complainant on 7th November itself has registered an FIR before Kolaghat police station, where he's a witness, my lords, in the FIR. So that I'm not able to join the investigation, he's also filed a frivolous FIR before the Kolaghat police station, my lords. My lords, I don't have the copy, my lords, as of now. I've not been able to procure the copy.
Have the copy. If you don't have the copy, we can't help you. If you have the copy, we will give you protection in that case.
My lords, I'll obtain the FIR as soon as possible.
We don't acknowledge the arrogance of a litigant not to come and join investigation.
My lords, I was diagnosed with dengue, my lords.
All dengue stories. Where is your document on dengue? We don't. What
My
is
lords,
that?
I have filed an affidavit to that aspect, my lords.
Yes.
Where is your dengue document?
My lords, the document is not there. I have filed it. I have written in this my affidavit.
The counsel, we make it clear, we will record that we are rejecting your bail application just on the ground of your obstinacy not to join investigation.
My lords, I will join the investigation, my lords.
So, we don't want your words. We want action.
My
Go
lords,
join.
my lords.
You meet the investigating officer on Monday. We're keeping this on Tuesday. We are surprised to note that the petitioner has chosen not to join the investigation and report to the investigating officer on 11/11/2024 or thereafter. It is his counsel contends that his client was suffering from ailments and seeks leave to file a supplementary affidavit. Supplementary affidavit is taken on record. There is no whisper of any medical document showing medical emergency which would have stood in the way of the petitioner cooperating with the investigation. Stop. Under such circumstances, we give the petitioner a last opportunity to meet the report to the investigating officer on Monday, that is 25th of December 2024 at 12 noon, November 2024 at 12 noon for interrogation. He shall submit necessary documents to the investigating agency in support of his defense. In the event he fails to do so, subject to the compliance of this direction, interim order is extended till 29th of December 2000, November 2024. However, if he fails to comply with this direction, shall be open to the investigating agency to arrest the petitioner for the
My lords, one humble request, my lords. My lords, one humble submission, my lords may record. My lords, I bow down, my lords. The complainant has also filed a frivolous FIR against me on 7th November itself, my lords, before Kolaghat police station.
It's a oral statement, nothing on my, in my knowledge.
There was no interim.
No, if he has to come, he may require, because your officer may arrest him. So, but we would like him to cooperate and join the investigation. He shall not be arrested in this case till 29th. He shall join the investigation, produce documents. ওটা আগে বলা আছে. We keep this matter on Wednesday.
My lords.
You are complicating your case, sir.
My lords, I understand, my lords. I bow down, my lords. I was suffering from dengue fever, my lords.
But we cannot help an obdurate
Lords,
litigant.
I understand.
To show that flexibility.
My lords.
Yes, next matter.
I am for the petition, my lord.
Well, Lordship asked me to take instructions, my lord, with regard to the quantum of pilferage. The final assessment I have obtained 1,87,127.
Petitioner undertakes to pay 50% of the bill for unmetered consumption to the tune of so and so within 7 days. Within 7 days, matter will appear 10 days.
Well, bill maybe give him to the petitioner, no bill.
Very well, I will.
Copy of the bill is handed over to learned lawyer for.
In course of this day, I will hand.
In the course of it. Next.
14, I am for the petitioner, my lord. My lord, allegation under section, though, my lord, the FIR was registered on 3rd of September 2024, but they have registered in IPC sections they have given in the FIR.
Yes.
Petitioners are the agent of Bharat Pay.
How FIR is registered under IPC?
Well, this is not really understood, my lord. Here,
I have
the
to,
memo evidence, my lord, they have given the corresponding sections, but in the FIR, I find that it is like the FIR also is the sent to me, my lord, is also quite illegible actually. My lord, I've just received this case study today.
Please get it corrected.
Lordship.
Ask the OC. We note that the first information report, which was registered on 3/9/2024, has been registered under the repealed Indian Penal Code. Officer in charge is directed to add the corresponding offences under in BNS to the FIR. Original case diary we produced.
Lordship.
Matter will appear on Tuesday.
Lordship.
hello, wait, can it be Wednesday, my lord?
Wednesday.
Wednesday.
Next.
Great, my lord.
Yes.
I am for the petitioner.
আদিত্য মান্না আদিত্য মান্নার কেস তো ময়না পিএস ময়না পিএস সিডি আছে ও ও আচ্ছা
Next.
My lord, Monday I will receive the case diary. Kindly keep it for Tuesday, man.
Monday will receive, we will take it up on Tuesday.
307
307.
All
There
right.
was some injury. my lord.
Tuesday.
Diplo.
Next. Yes, Mr. Mit.
My lord, the victim is at page 11 and at page 13, the Lordship has passed the orders granting bail to the co-accused. The victim, he died of a road accident. I am the widow of the deceased, my lord. Everybody has been granted bail. My lord, I had joined the investigation also. My statement was recorded. This is the statement.
Okay.
My
We have
lord,
seen it.
This petitioner is the wife of the victim.
Did he die out of the assault, or did he die of an intervening event and his subsequent death? We have considered the materials on record. Learned Counsel contains petitioner is the widow of the deceased. She has been falsely roped in. Materials on record show after the alleged incident, petitioner had suffered a road accident and was rehospitalized. Rehospitalized, he subsequently he died. He prays for anticipatory bail. The learned lawyer for the state contents the petitioner deceased was learned lawyer for the state submits petitioner had motive to commit the crime.
Petitioner had a relationship with one of the
petitioner had illicit relationship with the co-accused and had motive to commit the crime. We have considered the materials on record. Petitioner is not one of the assailants. Full stop. That apart, the deceased was released from hospital. That apart, after the alleged assault, after the assault, victim was released from hospital and suffered a road accident. Then he died. In this backdrop, it is doubtful whether the death was due to assault or the intervening road accident. Under such circumstances, co-accused have been released on regular bail. Petitioner is entitled to pre-arrest bail.
Obliged. Lord, I am for the petitioner.
statement.
Lord, the allegation under section Lord 85, 82, and Lord 34 of the Lord the new act and Lord corresponding Lord the charge sheet in this case Lord submitted under section 498 and 306. Lord, this petitioner before your lordship, Lord, the mother-in-law and the uncle-in-law. Lord, the husband in this case, he was arrested.
80 subsection 2 is miscarriage.
No.
No.
Dowry debt.
Dowry debt.
Dowry debt.
My lord. And my lord, the husband, he was arrested, he was granted bail by the learned. My lord, I am the mother-in-law and the uncle-in-law.
Uncle-in-law.
How many years after marriage?
My lord, 5 years of marriage.
5 years, within 5 years of marriage, my lord. There is a death due to effect of, my lord, poison, my lord, but unable to bear, my lord, the torture, she consumed poison, my lord. That is the statement, my lord, of the mother.
Petitioner submits that they are the in-laws of the victim lady. They have been falsely implicated. They pray for anticipatory bail. Learned lawyer for the state submit victim committed suicide. Victim died due to poisoning within 5 years of marriage. We have considered the materials on record. Statements of witnesses show petitioner used to suspect illicit relationship between her husband and another lady. Petitioner বলছি, deceased wife.
This
Petitioners are the in-law, are her in-laws.
Mine.
Keeping in mind the extent of their complicity in the offense, we are inclined to grant answer. Between her husband and another lady. Next.
Honorable for the petitioner.
For the state.
Under the NDPS Act, on the basis of co-accused statement, my name transferred. And as per instruction, my lord, charge sheet has been submitted.
Co-accused statement, however, CDR is there with the petitioner and the persons who have been arrested. CDR is there. Charge sheet has been submitted. And as per their statement, my lord, this petitioner is
We
the
have
kingpin.
considered
They
the
are the
materials on record. Apart from statement of co-accused before police officer implicating the petitioner in dealing in narcotics. Case call detail records. There are call detail records showing frequent conversation between petitioner and co-accused. Though petitioner did not join investigation and absconded. Though charge sheet is filed, apprehension and interrogation and further interrogation of the petitioner in course of petitioner in course of further investigation may reveal incriminating materials in implicating him in the crime. Accordingly, we are not inclined to grant answer.
My lord, I am for the petition. My lord, allegation under section 117 and 109 of the DNS.
My lord, injury, 2 persons are injured, 2 persons injured. My lord,
Why the assault took place?
My lord,
why assault?
my lord, regarding a goat has eaten rice from
All right. We
once.
have considered the materials on record. Incident occurred in the course of a village dispute. Injuries are not grievous under such or life-threatening. Under such circumstances, we are inclined to grant answer. Next.
I am for the petitioner. My lord, allegation under section 399 and 402 of the Indian Penal Code on the basis of co-accused statement and my name transferred.
4 accused could be apprehended, out of them, but not these names transferred. And the seizure, my lord, 6, 7, 8. And the co-accused statement, my lord, 10, 11. Charge sheet has already been submitted.
We have considered the materials on record. Complicity of the petitioner transferred from statement of co-accused before police officer, which is inadmissible in evidence. Investigation is complete. Accordingly, we are inclined to grant answer.
Grateful.
Next. And for the petitioner, a simple injury,
simple injury,
accused on same footing was granted anticipatory bail.
We
Charge
have
sheet
considered the materials on record. Injury is simple. Co-accused have been granted anticipatory bail. The petitioner stands on the same footing and may be granted similar relief.
Grateful.
Next.
24, I am for the petitioner.
For the petitioner, case under section 4, case under section 424 and 6 of the Indian Penal Code, I have already, my role is particularly of a brokerage, broker, as I have only sole incentive has been my brokerage, and also I have cooperated with the investigation. I have complied the notice under section 35(3) of the
If they have, after taking money from us, they have sold the land
That
to
is,
some
that is not, I am not taken money.
Petitioner submits that he was a middleman in a land transaction. Dispute at its height disclosed breach of contractual obligations. He cooperated with investigation. He pressed for anticipatory bail. Learned lawyer for the state opposed the prayer. Learned lawyer for de facto complainant submit. Petitioner and accused had induced her to pay her client
1.5 lakhs.
to pay 1.5 lakhs for purchase of land. Was sold to purchase of land,
For purchase of land.
which was sold to a third party. We have considered the materials on record. Petitioner had negotiated. It is contended petitioner negotiated a sale agreement between the de facto complainant and the co-accused. Initial payment, an advance was paid by the de facto complainant, but the land has been sold to a third party.
But I had no wrongful, but there has been no wrongful.
A third party. Petitioner has not received the money and cooperated.
That is incorrect, ma'am.
Bank
So far
statement.
as the cash amount that was collected, it was collected exclusively by the petitioner.
Any receipt given?
In the bank account, bank account, the state, the transaction.
No,
Right.
there are two types of transaction. One is cash amount.
Right.
But
The cash, any in the receipt was given. Then no documentary evidence is placed on record that money was handed over to the petitioner.
there's a money.
The money receipt that has been received not by me.
But the statement says that he had
money
collected the money for
The signature
Well,
is
that-
there.
but that-
The signature
I-
is there in the money receipt, in the
Well,
low portion.
I was the intermediary.
Lower portion.
I was the middleman.
Subroto Rai.
I'm not sure. I'm not sure.
Signature. Short signature.
Money was received by co-accused. Under such, petitioner has cooperated with investigation. Under such circumstances, we are inclined to grant anticipatory bail to him, subject to condition, meet investigating officer once in a week. Next. Documented evidence.
Correction.
My lord, kindly allow me to add section 76 of the BNS of the Bharatiya Nya Sanhita, which is 354B. My lord, kindly allow me to amend the cost title by adding section 76. 76.
Liberty to amend the cost title.
My lord, the dispute is between the developer and the owner. My lord, this petition number 1.
We have considered the materials on record. There was a dispute propped up between the parties over development of property. Allegation of outraging modesty appears to be embellished to give a criminal profile. Under such circumstances, we are inclined to grant anticipatory bail subject to.
My lord, over development of property, my lord has noted. My lord, it will be over owner's allocation. Dispute is over owner. The property has been developed.
Over allocation of apartments in a property.
Great.
Next.
Lordship. Lordship, I am for the petitioner. The petitioner
अंडरग्राउंड हो गया 6 महीने के बाद निकले yes
Lordship, the petitioner lent 1,36,000 sum to the complainant's father, and it's an admitted fact that the petitioner went to the complainant's father's house to recover this particular sum of money. After that,
Statement, this petitioner kidnapped the victim. Then this is the 164 statement.
142 is 140 and 140 kidnapping. They are available. This one 140 volume 2, subsection 2 and 5 137 364 5 ki na de.
Lordship,
मुझे तो बोलो kidnapping for ransom 364A. There's nothing as 140 subsection 5.
Lordship is kindly grant me leave to rectify the cause title. It's stating in 140 subclause 3 instead of like 140 subclause 5 instead of 140 subclause 3.
The materials on record, petitioner and others had kidnapped the victim to extract money. In view of the his statement implicates the victim's statement implicates the petitioner. In view of the nature of the crime, we are not inclined to grant answer.
Oh, nice.
I got that in the 364. Yes, next matter.
Madam, for the petitioner. My case under section 85, 80, and 3 and 5. But it's a complicated case.
Complicated.
Because husband, now my lord, husband is not the accused in this case, my lord. Because kindly see the 7 in my petition. Kindly see only for a moment.
What will you see?
But it is true, my lord, there is a love and relationship between the
paragraph 7.
My lord, kindly.
Your you are the husband.
No.
Then
I am
that man.
Because of my lord, the victim was not happy. No, there is
picture of the deceased, my lord.
no.
But how can it be 304B? It will be at best 108. 108.
Investigation is going on, my lord. Next time. That is not submitted, my lord.
My lord, I am ready to hand over my phone. If there is, my lord, kindly.
For you, someone commits suicide, you will hand over phone and get away.
That is not the main reason why she suicide.
That is not the main reason for suicide.
Only because, my lord.
Only because husband misbehaved with her, she committed suicide, not because of you. And they are saying that you threatened her to make your pictures viral.
No, my lord.
No.
The husband found some picture from the mobile of the lady who committed suicide, my lord. That's why the original dispute.
If I had to say something else, let us see that one.
The 164 statement, my lord.
164 statement.
If the father thereafter might the mother, my lord.
You're wrong section. 108 should be added. 306. Then- So who has added this FIR? Who is this wonderful police officer adding 80? Where is the demand of dowry? Is this accused a relation? In-law? Where are the ingredients of 80?
Next is the mother. Several statement of the friend of the deceased also, Malad. Is 56, 57, and 58.
Hmm. Who is accused number 3? Is Sumon Banerjee, Sukumar Banerjee, Nishit Banerjee are the in-laws.
My lord. They're on bail, my lord.
Petitioner submits that he is not related to the husband of the deceased. Husband suspected illicit relationship between the petitioner and the deceased wife. Deceased wife target here. Deceased wife. He misbehaved. He tortured her, and she committed suicide. He prays for anticipatory bail. Learned lawyer for the state submit. Petitioner had blackmailed the deceased wife by threatening to circulate objectionable pictures. Few days prior to the incident, he came to the paternal home of the deceased and threatened her in a drunken condition and threatened her with dire consequences. Subsequently, she committed suicide. We have considered the materials on record. In the FIR, mother of the deceased stated that petitioner was blackmailing the deceased with objectionable pictures. But this statement is significantly absent in her. But this version is significantly absent in her statement before magistrate. On the other hand, it appears that there was illicit relationship between the petitioner and the deceased. Possibility of the husband and in-laws chastising the deceased over this issue cannot be ruled out. Under such circumstances, we are of the opinion petitioner may be granted anticipatory bail. Meet investigation of the month. Parents send her again back to nothing. That he had come back. She didn't want to go. अब ये लड़का को अरेस्ट करने को you will be no, it will be unfair. Yes.
But non-bailable sections are 118(2), that is 326, and 74, that is 354. Now, my lord, allegation is I, in presence of my wife, over a dispute.
This is classified simple. Next 2 page lordship, that is not classified.
My wife was present at that time, point of time.
What?
My wife was present at that point of time. As he is alleging that
Who stops you from outraging modesty in front of your wife?
My lord, only allegation is I pulled the sari of the mother, who is aged lady. My intention, kindly consider.
Your intention is to harass a woman.
No, my lord, not at all. Family dispute, all are present. My family and their family.
Petitioner submits that there was a family dispute between parties and he has been falsely implicated. He prays for bail. We have considered the materials on record. Allegation of outraging modesty is against Sheikh Kanchun. Full stop. Injuries appear to be simple. Under such circumstances, we are inclined to grant bail to the petitioners. Anticipatory bail to the petitioners. Hello.
Grateful.
They are not Sheikh Kanchun.
No, my lord, for subject. No. My lord, the petitioner number 1 is alias Kanchun.
Alias Kanchun. Kanchun is rejected.
Yes,
1 is rejected, 2 allowed. बताओ
না না যে কাঞ্চন বলে দিলাম কোর্টকে কেন
Kanchun, 1 rejected, 2 allowed. No.
Next.
1
rejected, 2
1 rejected, 2 allowed.
Alias
I'm for the petitioner, my lord. I'm praying to not press these applications, and I have the written instruction from the petitioner for this.
Why?
My lord, she doesn't want to proceed with.
No, we want to. Why she doesn't want to proceed? Why she filed? We have considered the materials on record. Allegation in the first information report disclosed.
My lord, I beg to appear for the petitioner, my lord, in this matter, my lord. My lord, we have written instructions from the client, my lord.
Ignore the instruction.
My lord, then, my lord, may I address your lordship on merits, my lord?
Is that liberty to address?
My lord, the principal accused, my lord, in connection with this incident proceeding has been enlarged on bail by the learned court below. And my lord, the FIR, my lord, does not disclose, my lord, anything against her. All allegations are against the principal accused, that is the husband. My lord, he is on bail. He has been enlarged on bail by the learned court below.
The wife of the principal accused.
She was at that time, she and her husband took 20 lakh rupees and promised to provide job in the primary school as a teacher, your lordship, and give an appointment letter which came out to
we have petitioner contents. She is not the principal accused. Her husband has been released on bail. She prays for anticipatory bail. Learned lawyer for the state submit petitioner is the Pradhan.
Well, she happens to be a primary school teacher. She's a primary school teacher and was an erstwhile pradhan. She is a primary school teacher.
Is an erstwhile pradhan, and in collusion with her husband had induced innocent persons to part with money on the false promise of giving employment. Fake certificates were also fake appointment letters were also issued by them. We have
Well, a
considered
charge sheet has been submitted, my lord. My lord, and fake certificate.
have considered the materials on record. The petitioner had submitted. Petitioner is not an innocent housewife. She was a former Panchayat Pradhan and is a teacher in a local school. She colluded with her husband and made false representations to induce job seekers.
But there is nothing on record with regard to that, my lord. There is nothing as such on record.
If,
But that is merely allegations, my lord.
naturally, to part with money on the false promise of giving employment. In view of the nature of the offense,
All allegations against the husband, no allegations against the wife. No allegations.
Next.
Lamp for the petitioner.
The case diary not received, my lord. The case diary
today.
not received.
Not today.
My lord, I am for the petitioner. Case is under section 115 subsection 2, 117 subsection 2, 109 of the BNS Act corresponding.
I'm for the seat. Lordship, like the
injury
report. Injury report is on page 16 and page 18.
এটার পরে 5 মিনিট
Page 16 backside
34 Yes, thereafter what happened? What is the CT scan?
My lord, there is 19 my lord stitches in my son's head, my lord.
Where is the CT scan? Where are they? Do you have additional medical papers?
Not with me.
It says that refer CT scan and X-ray of spine, etc.
Not with me, not now. My lord.
Huh?
Not with me now.
Find out. Monday. Next.
Not have served to the service.
Yes, Lordship, my paper.
Two persons have already been granted bail, Lordship. Yeah, from co-accused statement.
Same footing, Lordship.
Bihar, Lordship.
Bihar.
Same footing, Lordship.
Huh?
2% already granted bail, Lordship. Anticipated bail.
So the second of Bihar.
Carrying cows, Lordship. Yes, Lordship. True lorry, Lordship. Lordship.
No, 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 no.
As far as the order of the lower court is concerned, 8 cases are there. Against all of them who has been granted with 8 cases.
The person already granted anticipatable from this court lordship.
Before Harishchandra PS. Go ahead.
Lordship, 2% granted the same footing lordship from this honorable court lordship. Yes. But not a smuggler lordship. No, no, lordship. No, no, lordship. The cattle are not seized from the border area, lordship. Lordship, carrying cattle of those.
Is complete, exhausted.
Lordship, kindly consider. 2% granted, the same footing, lordship. Already given. Lordship. Lordship. Not present. Develop.
35 to 36.
36
But in 35, I'm for the petition appellant lordship. 10 years conviction, above 5 years already suffered lordship.
Suspension is filed in 36 only. 35.
35.
35,
Appellant
madam,
has
in respect of Bidjum only, earlier rejected. On February 2nd.
But I am here. But the only difficulty is that but I have filed any bail application.
So we are not going to give you bail. Don't worry. There is no difficulty. You will remain in custody. Appellants have suffered incarceration for more than 5 years.
That's 1 month.
That is half of the maximum sentence imposed upon them. Full stop. Appellant accordingly they renew. Accordingly they pray for suspension of sentence. Learned lawyer for state submit. Prayer for suspension of sentence of appellant number 1 had been turned down earlier. We have considered the materials on record. Prayer for suspension.
Appellant number 1, that is Bidjum only, because here it is another, that is Peter is also there.
Prayer for appellant number 1, Bidjum only, was turned down on merits. Presently, appellants pray for bail of suspension on the ground that they have served more than half of the maximum sentence imposed on them. In light of the aforesaid submission. Now we note paper books have been, we note that appellants have served out 5 years, have served out, are in imprisonment for 5 years, more than 5 years, and the maximum sentence imposed upon them is 10 years. Though paper book is ready, the appeal relates to 2022 and there is little possibility of this matter being taken up in near future. Under such circumstances and in light of the right to speedy justice of the appellant and in light of the fact that right to speedy justice under Article 21 extends to appellate proceedings also, we are inclined to suspend the sentence of the appellants. Suspension of sentence on the ground of delay in proceedings infracting right to speedy justice is not restricted, is not regulated by restrictions under 37 of NDPS Act.
Grateful.
Please don't waste our time. Next. Next.
37 will I am for
Rejected earlier?
No, my lord. First time.
Second is the conviction plea.
But we were always on bail. There are 2 stories here, my lord. The story was disbelieved in respect of a motorcycle accident. But the other story of 7 DWs was given. I've never, in my lifetime, I've never seen such a case. We were always on bail.
There are too many witnesses.
There are eyewitnesses, but I can't deny that factor, madam. Then keep it in January, madam.
Appellants contend, paper book not ready. Appellants contend that the
paper book হয়নি এটাতে LCR এসছে ও আচ্ছা
file has been received, so in January
yes, keep it
say
there.
by January paper books be prepared. We have considered the evidence on record. A number of eyewitnesses have implicated the role of the appellants in the assault. As a result, the victim died. Defense version of death by road accident.
Motorcycle accident.
Death by road accident has been improbabilized. Under such circumstances, and as the sentence is one of life imprisonment, we are not inclined to suspend the sentence. Paper books be prepared within 8 weeks.
So, January. January.
8 weeks.
Yeah, January.
39 today?
সরি তোকে আমি না ভুল বলছি এটা বুঝছি
কোনো order হবে না। এগুলো তো ক্র্যান হচ্ছে 36 আসছে because it's a connected appeal.
I am led by Mr. Sapir Ahmed, Lordship. I am praying for only not today,
No,
Lordship.
no, there is no not today.
Lordship, he is, due to his personal difficulty, he could
I
not
have
come.
told you there is no not today. Oh, you
Lordship, he has mentioned this matter in the morning before your Lordships.
The paper book is prepared.
paper book read. Not today.
Deeply obliged, Lordship.
তুই আছিস নেক্সট মালা 326 307 first time 10 years.
How long you in custody?
2 years.
Paper book has been prepared.
Appellant is in custody for 2 years. Sentence is one of term imprisonment. Though paper books are ready, appeal.
It's ready.
Though paper books are ready, appeal relates to 2023 and there is no possibility of the appeal being taken up for hearing in near future. In view of the aforesaid facts and the law declared in Rama Shinde, we
Bosai.
are inclined to suspend the sentence.
Grateful.
Next. High-gander হইল।
Lordship, item number 40 is a legal aid matter. Lordship, Mr. Mondal hasn't come to the court today.
So what? You are there.
But, what is
If your Lordship kindly takes it up on Monday.
302 Lordship, conviction and sentence up to life.
What is the evidence against?
Evidence that was strangulation by the doctor stated. And my lord,
But all of them have been
and
convicted.
we have the 1, 2, 3, 4, 7 and 10 eyewitnesses.
Huh?
From the record we find, and my lord, there is no order sheet in the annexed in the
How can the trial judge impose life imprisonment up to death?
date.
Huh?
That is I find.
We cannot. Life imprisonment means
Life is-
till the end of life.
Yeah.
We have considered the evidence on record. There was strained relationship between the appellant and his wife. On the night prior to the incident, witnesses stated in the night prior to the incident, there was quarrel between them. Wife was murdered at the matrimonial home. In view of the aforesaid clinching evidence on record, the conviction has been recorded. Sentence is one of life imprisonment. Accordingly, we are not inclined to suspend the sentence. Next.
না applicant বলছিল legality
আমাদের 300 to 34 মানে conviction 334 life 3 persons. I am in custody, we are in custody near about 2 years.
2 years over. Life imprisonment come after 10 years.
My lord,
Paper book prepared.
Paper book prepared.
My lord.
My lord, there are
Eyewitness.
injured eyewitness, PW2.
Then
there are eyewitnesses.
We have considered the materials on record. Eyewitnesses implicated the appellants in the assault resulting in death. PW2 is an injured eyewitness in view of the aforesaid evidence. On record, conviction was in view of the aforesaid evidence. Conviction was recorded. Sentence is one of life imprisonment. Paper book has been prepared. Appeal is ready for hearing. Hence, we are not inclined to suspend. Next, take the paper book. The parties are requested to collect the paper.
It will appear in the list.
Next.
For part one. 1 year, 9 months I am post conviction, and before that 3 months. Total 2 years I am in custody. Imprisonment for 10 years, my lord. In default 1 year.
Appellant is in custody for 2 years. Sentence is one of some imprisonment. No aggravating circumstance is placed on record. Appellant was on bail during trial and misused and did not misuse his liberty in view of the aforesaid circumstances, and the law declared in Rama Shinde. We are inclined to suspend this sentence.
My lord, out of 2 years, 3 months was before trial. Not 2 years.
Next.
I'm for the appellate in আমাদের appellate কোড আছে এটা একজনের একজন
My lord, and their lordship in this case, my lord.
একজনের
হ্যাঁ ওইটাই বলছি।
তো আমি একজনের ক্রাইম পেয়েছি আর বাকিতে জানি না আমি কে
Two. 1 page না 2 page?
সাজ্জাদ
হ্যাঁ আমি সেটা দিয়েছি আমি দিয়েছি।
হাদিস শেখটাই পেয়েছি আর
My lord, best say one thing. My lordship doesn't read the judgment now, my lord. My lord, on the 8th of February 2023, this order of conviction was passed. In the meantime, my lord, 2 absconding accused persons were taken into custody. Then my lord was pleased to pass this order. Your lordship sitting
The record
has got back to that court.
let them be convicted.
But the paperwork is here, man.
But the paper book has been done without the LCR. The matter cannot be heard. That is, so lordship, let us keep the status there. Then your lordship hears another day, my lord. Or call for a report. My lord, status where Mr. Roy could get a status report.
Trial court shall submit report with regard to the progress of trial of absconding accused.
Yes.
Matter will appear 4 weeks hence.
4 weeks will be vacation.
Today is
20. Oh, that's 20. Sorry, my lord, sorry.
24.
Sorry. My lord, the next 3 matters. Mr. Basu is in one with my lord,
5 to
46 to
46 to 40.
My lord, we have just
49 I am for the appellate.
We are missing the my lordship's criteria. 8 years, 5 months.
About 9 years.
9 years.
But I am for the de facto complaint in all the 4.
48 applicants are there in 46.
Paper books are ready.
The paper books are ready.
We add it for here.
Lordship. 8 year 1 month and 7 year.
All
Oh, তাই তো বলছি আমরা তো বলছি we not fulfill the criteria. But only one thing, Sheikh Shahjahan has passed away.
In 48.
In 48, he has passed away.
Submit the death certificate.
Medical report you will also ask the last time, my lord.
All right. Record an order in 48. Appellant number 1. Appellant number 1 has passed away. Medical.
My lord, this is so the month of May, my lord.
No, subsequent.
serious condition, my
That's subsequent.
Where is the?
No, on that note, he was
Granted
released on
bail.
bail, but later on he has succumbed to it.
Yes, but we want the death certificate.
Death certificate.
We'll give it.
Give it to him.
Then let the death certificate be given. As of now,
So doesn't pass out, keep it on.
when it is coming up for hearing.
Okay, man. Grateful. Well, keep it in January monthly list.
Bail prayers have been rejected earlier in respect of appellants.
Well, it is pending. No, they were rejected as such.
It wasn't rejected. Acha, paper books are ready. In view of the fact that the appellants have suffered incarceration for a considerable period, let the matters appear in the list for hearing. In the monthly list under the heading hearing in January 2025. Full stop. We are informed appellant number 1, Sheikh Shahjahan. Appellant number 1 in CRA DB 10523 has passed away. Death certificate be placed on record. All right.
Grateful.
All are same.
একই সেম তো একই কেস তো তোমার কত
49.
আমাদের সাথে একই কেসে
But so far 49 is concerned.
46 to 49
49 is concerned, but on the health ground, I have made an application. He was in Bardhaman Hospital. His condition having deteriorated, he was transferred to SSKM Hospital. But now his condition has further deteriorated. But your lordship will kindly call for a report.
49
But this is the supplementary affidavit I am filing.
Appellant is, it is contended appellant is seriously ill and has been hospitalized. State shall submit report with regard to his medical condition. Matter will appear 2 weeks hence.
I'm deeply.
Nothing.
Well, supplementary affidavit file may be kept on record.
আগের অর্ডারটা দিও না হ্যাঁ শাহজাহান ডেথ সার্টিফিকেট and Sheikh Babu so-and-so. 2 weeks hence we keep it. Let us see and give us who are the ones who are on bail and who is not on bail. We'll pass the orders after. Next.
My 50 my lord, I'm for the appellant my lord. My one blow by a crowbar, person died. My lord, conviction of life, 3 years and 3 months in custody. My lord, paper books not prepared.
We have considered the evidence on record. Appellant had assaulted the victim on the head and he had expired. In view of the aforesaid evidence, and as sentence is one of life imprisonment, we are not inclined to suspect.
But 304 at best, my lord.
When we will hear, we will consider. Still then he will get 7 to 10 years, isn't it? So wait now. Why do it after 10 years? Huh? Nah, ওটা 2 weeks পর আসবে. Next.
Lord, I am appealing for the appellant. 498A304B sentenced to 10 years imprisonment. Appellant is the husband.
How long you are in custody?
My lord, 1 year, 10 months, more than 1 year.
Petitioner is in custody for about 2 years. 10 months or you have extended it to 10 months?
No, more than 1 year, 10 months.
All right. He is in custody for more than 1 year, 10 months. Sentence is one of life, one of term imprisonment. No aggravating circumstance is placed on record. Appellant was on bail. Was he on bail during trial?
Yes, my lord. 12 years I was on.
Was on bail during trial and did not misuse his liberty. In view of the aforesaid circumstances and Ramashinde Gosai, we enlarged the appellant on bail.
Grateful.
Next.
Let me consider my application, my lord.
I have instructions to appear on behalf of the de facto, my lord.
My lord, case of 498A, my lord, and 302, my lord. Initially, my lord, 3 persons has been tried before the learned trial court. 2 persons has been acquitted.
one is before your lordship, my lord, husband is before your
302
lordship.
conviction.
My lord, the lady suffered, my lord, burn injury on, my lord, 23rd of April. He died, my lord, on 28th of April. During her lifetime, my lord, he has not made any statement. Although, my lord, the prosecution case is that during the ambulance, my lord, there was a oral drying declaration before one of the relative, my lord, that husband set fire on her, my lord. This is the oral drying declaration. But, my lord, during her lifetime, that span 5 days or 6 days, my lord, no, so far my understanding, my lord, nothing has been recorded, my lord. This is the crux of the fact. I am in custody about 20 months after conviction, my lord. Post conviction, my lord.
Appellant submits that the alleged oral dying declaration to family members is improbable. Though
Doctor, my lord.
victim survived for 5 days,
5 days, my lord.
no dying declaration was recorded in presence of the doctor.
Well, it was
No.
It was, my lord.
Doctor
Kindly
said,
see PW5.
doctor said they have.
Once again, this is his
My lord.
submission.
My lord, my lord.
He prays for the suspension of sentence. He is now you make your
My lord.
submission.
My lord, victim,
Victim, there is eyewitness
my
to
lord,
the incident.
doctor is the eyewitness, my lord, and my lord,
PW,
doctor supports the case, my lord.
PW,
PW6 is the victim's daughter.
how the doctor supports the case?
My lord, doctor said that, my lord, the burn was, my lord, it was, my lord, sparks was applied. My lord, the burn, my lord, he poured the kerosene oil, and thereafter, my lord, gas pipe was opened, and my lord, spark was.
How the doctor knows?
My lord,
How the doctor is able to say that?
my lord, that is his evidence, my lord, PW5.
Appears to be a bit overzealous, isn't he?
Well, kindly takes up internal page 7 of the judgment once. PW5, PW6 is given over there.
6 we are relying.
Well,
PW6, daughter of the victim, has implicated her father, that is the appellant, in setting, in murdering his wife, in murdering his mother, her mother, in view of the aforesaid evidence on record, and as sentence is one of life imprisonment, we are not inclined to suspend this.
My lord, daughter said by gas, my lord, but in case of kerosene, my lord.
That brilliant, very big difference.
This is the thing, my
He
lord.
said
Daughter,
kerosene as well.
that kerosene oil is poured. Daughter said gas was opened, and my lord, they stuck that. This is
Maybe
He
gas
mentions
also was open. Maybe gas also was opened. Who knows?
that is the thing, my lord.
Why should we disbelieve a daughter speaking against her father?
They said they're regarding poor, my lord. Very well, my lord. My lord, kindly direct to paper book, my lord.
Paper books within 8 weeks.
Great.
Next.
53, my lord. I am for the appellant. My lord, 9 years, 4 months, as per my instruction, I am in custody. Paper book yet to be prepared. My lord, I have been convicted. Kindly come to page number 4 of the judgment. 161 has been exhibited. Confessional statement.
Paper book doesn't matter. Paper book be prepared within 4 weeks and placed on record. Adjourn 4 weeks.
That's right.
B.
I mentioned in the morning, my lord, that is listed scheduled for 25th. But since, my lord, the mother expired, I mentioned the matter, my lord. And I have already intimated the other side that the matter will be listed. The NCB, my lord, I've served, and we had a talk with the lawyer. He will be coming, my lord. He said so. My lord.
My lord, I am for the petitioner, my lord. My lord, petitioner is in custody for 3 years, 3 months, 10 days. Out of 12 witnesses, till date only 5 has been examined.
5 examined.
Well, out of 12, 5 examined. This is my renewal application, well.
When was it rejected? Then December 2024 has not come. Bail prayer of the petitioner was
Well, there is
rejected.
a previous direction whereby this earlier rejected on
Sir, in September, the trial judge was directed to conclude the trial by December 2000.
Yes, my lord.
Time
Well,
has not come.
but then may I not press this application? Oblige me.
Next.
On record. কবে দিয়েছিল রিপোর্টটা?
14 তারিখেই ডেট ছিল।
My lord, on the last occasion, your lordship said please to call for a report. My lord, I prayed for bail on the ground of parity. Out of 8, 7 are granted bail by this honorable court and also by this by the honorable Supreme Court. My lord, the evidence of IO is left.
How long you are in custody?
1 year, 9 months.
Petitioner is in custody for 1 year, 9 months. He renews his bail prayer. He contends who accused are on bail. He prays for full stop. He contends who accused are on bail. Therefore, he renews his bail. State submits report. From the report, it appears date has been fixed for cross-examination of investigating officer in February 2025. We have considered the materials on record. Other co-accused are on bail. Petitioner is in custody for
1 year, 9 months.
For 1 year, 9 months.
I am the driver of the vehicle.
Vital witnesses have already been examined. Cross-examination of the investigating officer is fixed in February 2025. Under such circumstances, we are of the opinion petitioner has made out a case for bail. Full stop. 10,000 to share. Next.
My lord, I am for the petitioner.
Time for the petitioner. Your lordship has already considered on 6th and 7th of this month, allowed the prayer for the co-accused.
Petitioner is in custody for
60 days, my lord.
60 days. No narcotics was recovered from his possession. Under similar circumstance, who accused has been enlarged on bail. Petitioner is entitled to similar relief.
Grateful.
Grateful.
Next.
Item number 4, I am for the petitioner, my lord. Petitioner is in custody for a period of 2 years, 11 months, my lord. My lord, kindly see page 53. Your lordship directed the, my lord, trial court to conclude the trial within a period of 6 months, my lord. 6 months had already been expired. In the meantime, my lord, Honorable Apex Court grant bail to the co-accused.
Regular bail. চলো কেমন আছো ভালো তো ভয় পাচ্ছ ও আছে দুজনে মিলে গোলাম
মানে
রেকর্ডিংটা করো না এই ফোনে রেকর্ডিংটা করছো তো
মানে out of 2 accused persons, 1 has been granted bail from the apex court. Page number 5. We are produced on the same date. I am in custody for 2 years, 5 months.
2 years, 5 months. He stands on.
Similarly, please.
We have considered the material. Petitioner is in custody for 2 years, 5 months. Co-accused has been granted bail by Honorable Apex Court. Petitioner is entitled to similar relief. Allowed.
That is SEM Barak.
Next.
SEM Barak.
My lord, I'm for the petition.
But I'm for the state.
Paying for bail on the ground of parity, standing on same footing.
No, I don't have the case diary, but I have gone through the petition, my lord. But their lordship has pleased to
Page
grant
12
bail,
of
my lord,
my-
on the co-accused, my lord.
Page
He's standing with
12,
the same footing. My lord,
How do you know?
Page 12, my lord. Kindly see. My lord, from the husband and wife, my lord, the heroin has been recovered.
2 years, 5 months.
Yes, yes.
2 years, 7 months, 16 days.
Petitioner is in custody for over 2 years, 7 months. On the score of delay in trial, co-accused has been enlarged on bail. Petitioner is entitled to similar relief. Allowed.
Grateful, my lord.
Deep privilege.
1.840 grams of ganja, my lord,
Just
was
got the
found from the.
notice, my lord. Just half an hour, just got the notice. my lord. I have no instruction as far as this case.
Regular bench.
But that I prayed before your lordship, my lord, the mother of the petition number 1 has expired on 18th, my lord. Page 20, Annexure C, page 20 of my application, I have given the cremation certificate.
Petitioner's number 1 contents his mother has expired.
Payroll, because I have
A inquiry be made with regard to the document. Inquiry be made and report be filed Monday.
Right, I am for the petition.
My lord,
Lord, 9, I don't have the case ready.
In
my
Monday.
lord, same footing, page 8, your
How
lordship.
will he know same footing, Mr.
Uncle.
But 108 of the BNS, but I am in custody for 120 days. My lord, two friends, my lord, they are separately married, my lord, they stayed in a hotel. They were in the hotel room. In the midnight, the victim lady committed suicide by hanging inside the bathroom.
Petitioner submits that he is in custody for
120 days.
120 days. There is no material to show that he abetted the commission of suicide. He
Previous
prays
night,
for-
my lord, there was a altercation between themselves, my lord.
That we see. He prays for bail. Learned lawyer for the state submit petitioner and co-accused.
No, my lord, petitioner and the victim.
Petitioner and the victim were staying in a hotel room. They quarreled. Subsequently, victim committed suicide. We have considered the materials on record. Statements of witnesses show petitioner and victim had quarreled before the incident. Mere quarreling may not constitute abetment of suicide. Yeah, abetment to suicide. It is possible that the victim may have acted impulsively in a fit of rage. Under such circumstances, investigation is complete. There is no chance of abscondence. Accordingly, we are inclined to charge. Next.
My lord, I am for the petition. 326, 307, my lord. Charge sheet submitted, my lord.
We have
57 days.
considered the materials on record. Petitioner
Well,
is in custody.
57 days, my lord.
57 days. Investigation is complete.
Injury report কোথায়?
Whether injury is life threatening, require
Well,
may be
they-
assessed at the appropriate
Injury
during
report is
trial.
there, my lord.
There is no chance of abscondence. Accordingly, we are inclined to.
This is
grant.
injury report, my lord. And this person. এক্সিডেন্টে হচ্ছে লিখে দিচ্ছি
Well, I am for the petitioner. Claiming parity. No, kindly see the observation passed by your lordship. Kindly see for a moment. No, don't. This is not a never statement, my lord. Kindly see the observation made by your lordship.
PM doctor has opined that the
Yes,
witnesses are not sufficient to cause death, but their neighbor
On
statements
that
do
score,
state
your
that they witnessed the incident. The victim was assaulted with bamboo.
All right.
My lord,
Petitioner submit. Petitioner submit the cause of death.
These are the 161 statements.
Petitioner submit that the medical opinion does not support a case of homicide. He is in custody for
214 days.
214 days. He prays for bail. He is the husband of the victim housewife. He is in custody for 214 days. Co-accused are on bail. He prays for bail. And a lawyer for the state submit. Neighbor stated victim housewife has been assaulted on the day of the incident. We have considered the materials on record, though neighbors stated victim housewife had been assaulted, medical opinion. Medical officer states that the injuries are not sufficient to cause death. Under such circumstances, co-accused Sheikh Morselem Ali has been enlarged on bail. Petitioner is in custody for 271 days and investigation.
214 days.
214 days and investigation is complete. There is no chance of abscondence. Accordingly, we are inclined to extend. We are inclined to grant bail to them.
Wait. PGM Howrah.
Next.
PGM Howrah.
Well, in 13, I am for the petitioner. Is the lady accused in custody for 9 months. My lord, 300 to 201. They were in live-in relationship. They used to quarrel every night. And on that very date, my lord, quarrel was made, a scuffling was made. Knife touched the abdomen of the my lord. It is unintentional.
The abdomen. And somehow intestine came out.
My lord, it's unintentional. My lord, your lord
Iron
knows very
abdomen
well.
knife is a magnet. It just attracted the intestine.
My lord, it's unintentional, my lord. Unintentional, my lord. 9 months.
Petitioner was in the room where the victim was murdered.
They used to stay together.
Was murdered in view of the gravity of the offense. We are not inclined to grant bail at this stage.
And God bless you.
Just touch the dust. And suddenly what happened?
My lord, item 14, I am for the petitioner. My lord, 5 out of 7 accused
I am
have been
praying for not
granted
to
bail
do
by this honorable
Siri not
court. My lord, parity 13th, your lordship granted bail to.
Let us see today parity.
My lord, we'll see. My lord, all orders are there. My lord.
Let us see. Fogla.
My lord, that.
Oh, that Fogla.
Yes, my lord. My lord, I am the 5 have been granted bail. 13th, your lordship granted bail.
Devki Nandan Sharma.
My lord, yes, my lord.
Who is Devki?
My lord, I am been made an accused in the 3rd supplementary charge sheet stating I was a co-conspirator who helped the accused persons make the DSC.
How long you are in custody?
310 days, my lord.
Only? They were in the custody for 700 days.
My lord, I understand. My lord, my trial is in progress. 30 witnesses have been examined, my lord.
Petitioner is in custody for
315 days, my lord.
315 days. He was not named in the initial charge sheets. Subsequently, he has been implicated as an conspirator. There is delay in trial. Co-accused have been enlarged on such score. Co-accused has been enlarged on bail. He prays for bail. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. Petitioner was not named in the initial charge sheets. On the score of delay, co-accused have been enlarged on bail. Petitioner is also in custody for a considerable period. Offences, if proved, would not attract mandatory life imprisonment. There is no chance of abscondence. Accordingly, we are inclined to enlarge the petition.
Deeply obliged.
Next.
So 50 I'm for the petition, your lordships. On
the
parity
state-
lordships, I'm paying for bail. One of the two of the co-accused person granted bail, your lordships, page 34 and page 37, your lordships. I'm in custody 4 years, 5 months, 18 days.
Huh?
Page 34 and page
All right, report has to be given.
37.
Please
your
find out whether they are in same footing.
Yes, lordship. Yes, lordship. My lord, kindly see the page 31.
31.
Fourth time, my lord. All are identified by TI parade and 164 also,
Then?
lordship, but they granted bail on the ground of delay in trial.
Where?
Page 30.
4 years. How long you are in custody?
4 years, 5 months, 18 days.
Petitioner is in custody for 4 years, 5 months. Co-accused Sheikh Chand has been enlarged on bail on the ground of delay. There is little possibility of trial concluding in near future. Under such, he is not the principal accused.
All are, my lord,
Together,
suspected
same
theft.
footing.
Suspected theft.
Of trial concluding in near future, there is no chance of abscondence. Accordingly, we are inclined to enlarge the petitioner on bail. Allow. Next.
16, your lordship, appearing for the petitioner, praying for bail on parity, your lordship, page number 30.
Not
Not appear for the petitioner.
My lord,
But-
I'm praying for an accommodation for
But
today.
at same footing,
also.
well, at
My lord, I'm praying for an accommodation for today.
but at same footing as Annexure A,
Pre-fancy
page
is
11, Untu
like
Mondol and Vijay Sarkar are on the self footing. Untu has been granted bail by your lordships. Principal accused is one Raju Chayal who fired. I am not the principal
We
accused
have
person.
considered the materials on record. Petitioner is not the principal accused. Co-accused Ontu Mondol has been enlarged on bail. He stands on similar footing and is entitled to same relief. Allowed. Sure.
Great.
হয়ে গেল যাও ভুলভাল টাইপ করে